All right, we are live. Welcome everybody to Housing and Real Property Subcommittee meeting for March 11th, 2026. We have a decent group of bills to discuss, vote, and then we're just going to have some discussion / work group on a couple of bills. A couple of things I want to lay out before we get started. For those of you who have joined, whether you are representing an organization or you are a advocate or however you want to title yourselves, I want to be clear. During the discussion portion of the bill and even during the voting session, unless you are asked to speak, that is when you will get permission to speak. So for instance, if there is a part of the bill that has caused people to disagree on, and a member of the actual subcommittee needs to ask a question from that group or a person that understands that topic, if that person wants to ask that question, they must then they must ask, and then that person can speak. So I just want to be clear, for our discussion, even for our discussion portion, we want to be fair and balanced. So unless you are asked a question, we ask that you refrain from speaking. And the other thing is, if you are on your cell phone or iPad or etc., please make sure you name yourself so we know who you are. All right. So with that said, we will get started with the bills. You have to excuse me, my allergies are bothering me today, so not speaking as well as I'd like to. So House Bill 313, landlord and tenant residential housing, rental applications and tenant screening. This is Delegate Stewart's bill, House Bill 313. Council, can you please give us a quick summary of the bill and then the amendments that we have here and what they are attempting to fix or do, and then we will also hear from the bill sponsor. Council.
Thank you, Mr. Chair. House Bill 313. This bill relates to rental applications and tenant screening. There's no state or local fiscal impact. As you mentioned, there are some amendments. As amended, what the bill does is DHCD is required to create a disclosure form for landlords to use that's going to provide information about the tenant screening report information, criteria for the denial or conditional acceptance of a rental application, the maximum amount that may be charged for an application fee, and then contact information related to the tenant screening report. Under the bill, a landlord is required to provide the disclosure to a prospective tenant before accepting an application fee. This way, the tenant can see what info is included in the tenant screening report and what can lead to a denial. There is some testimony about tenants having to pay a screening fee only to know that they would not be eligible in the first place. The bill prohibits a landlord from taking adverse action against a prospective tenant unless the landlord provides the tenant with notice stating the reason for the action. This reason cannot be based on shielded records or that there was no reliance on unshielded records that are 3 years or older, provided that it was not reasonably available information regarding the outcome of the claim against the prospective tenant, and then a copy of the screening report used by the landlord in reaching the determination / info for how the tenant can obtain the report. So the landlord has to provide a copy of that to the tenant, the prospective tenant. The tenant can dispute the information in a tenant screening report, and then a landlord may not generally require a tenant to disclose shielded records, rely on a tenant's shielded records in making a determination regarding a rental application. And then a person who is producing the tenant screening report may not disclose information about shielded records. And then last, there's a civil penalty provision for a landlord who's violating this of $500 per violation.
All right, thank you for that summary. So want to turn it over real quick to the bill sponsor. I see that Delegate Stewart is here. Delegate, can you just please provide any updates on, I know there was pushback on parts of the bill, and I think these amendments help cure some of that pushback. Can you please provide an update on your communication with those groups?
Yeah, absolutely. Appreciate it, Mr. Chair. So good news for the subcommittee is that I worked very closely with Matt Pipkin at MMHA, with a number of the other different landlord advocates. I believe that we're good to go on this bill. I believe that they have dropped their opposition. Obviously, if anyone wants to weigh in and contest that, I welcome that. But I believe that with these amendments, which we worked very carefully with them on, there were multiple rounds of amendments. They were very patient with me. I believe we've gotten this bill into a posture that they can live with.
You said it was Ioba. Who else? Who was it that you worked with?
Yeah, AOBA, MMHA, and the realtors. Matt Pipkin is on and now has his camera on, so he can tell me if I'm incorrect. But Matt was great to work with.
Hey, Mr. Pipkin, can you provide some context to that? We're all good. We're all good. Up, thumbs up here.
Thank you, Mr. Chair. And I do want to really commend the sponsor for working with us and having patience with me as I was working with my subject matter expert to deal with this on a daily basis. I want to say I think I can also speak, I think, for the realtors as well. I haven't had a chance to speak with AOBA. We're close. I think we still just have some lingering concerns with, just with general liability. And just the general liability within the bill. Again, the bill is absolutely in a much better, more workable posture. I cannot thank the sponsor enough. We really have had some great back and forth. I think, for my members, it's just there's still a lingering concerns with just overall liability, and it's not just simply for this bill. I would say collectively for a number of the bills as a collective. It's just there's a lot of angst with that.
Yeah, thank you. Brian from AOBA, did you have any comments?
AOBA's good with the bill. Thank you.
Right. Awesome. Mr. Greenfield, any other comments to add?
No, I think my colleagues before me correctly read the situation, and we, as always, thank Delegate Stewart for working with us.
All right, sounds like we're in a great posture to consider. Does anybody want to move the amendments?
Move the amendments.
Is there a second? Someone saying second. All second. Right. Amendments have been moved and second. All in favor of the amendment, say aye. Any opposed? Right. Amendments move. Is there a motion to move the bills amended?
Move the bills amended.
Second.
All right. Bill has been bill has been moved as amended and seconded. Any discussion? All right. If you're talking, I can't hear you, and I don't see any hands up. So we'll move to a vote. All in favor of the bill, say aye, and please raise your hand so my team can get a proper count. All right.
Aye.
Favor, aye. All right. All those opposed?
No.
Aaron.
All right, cool. So party line vote here. All right, thank you. We're on to our next bill. Let's keep this pace up. All right, this is House Bill 315, Human Relations. Oh, another Stewart special. Stewart, I thought we were done with you today, man. You said it's your last bill, and now it's subcommittee time.
I spoke too soon.
House Bill 315, Human Relations, Discrimination in Housing, Income-Based Housing Subsidies. Council, if you can briefly describe what the bill does and what the amendments now do with the bill.
Thank you, Mr. Chair. There's no state or local fiscal impact with this bill. There are the amendments you mentioned. As amended, what the bill does is a landlord may not refuse to rent to a prospective tenant who pays rent with the assistance of income-based housing subsidies on the basis of the tenant's income, credit score, or their adverse credit history that arose during a period when the tenant did not have an income-based housing subsidy, if this period was verified. And there's a number of ways for that. However, if a landlord receives funding from a government entity or nonprofit that requires income qualification for tenants in income restricted rental units, the landlord may collect financial information from a prospective tenant if the collection is a condition of this funding that they're receiving. And then there's also a landlord can still require verification that a tenant has sufficient income to pay that portion of rent not covered by the income-based subsidy using an income to tenant portion of rent ratio that is substantially equivalent to the ratio used by the landlord for non-subsidized tenants. The landlord can also still consider references from a prior landlord or the tenant's history of lease violations, nuisances, property damage. And the bill establishes that an action, a violation is a discriminatory housing practice subject to enforcement by the Maryland Commission on Civil Rights.
Thank you. Delegate Stewart, did you have any other comments or updates on who you worked with on amendments, and just give us a stance of where the bill is?
Yeah, I'd love to, Mr. Chair. So the good news here is I thought that we may have to have like a long drawn out discussion and a fight with the landlords on this bill on the subcommittee meeting, but unfortunately we broke bread this afternoon. Mr. Greenfield and Mr. Cantu from AOBA met with me and Emily Hovermail, one of the advocates for the bill, and we had a really great discussion. We walked through the entire reprint, and I just actually heard from Mr. Greenfield just a few minutes ago that they are no longer opposed to the bill as amended in the reprint. And essentially what the bill does now, we took, I believe, basically almost all of the landlord's amendments. We, again, had a really nice discussion with them that was productive. I think they basically got what they wanted out of the amendments here. As amended, essentially what this bill attempts to do is to prevent landlords from using non-predictive, old, irrelevant information against voucher holders, namely old adverse credit history from before they had a voucher, if the landlord knows when they got the voucher. Credit scores, for example, which are not predictive, but we made it very clear in the reprint that landlords still have the ability to income verify the tenant's portion of the rent. They still have the ability to look at tenant screening reports. They still have the ability to look at eviction history. They can still look at references from current and former landlords. So they have a whole panoply of options to look at actual predictive information so they can know if tenants are not going to pay their portion of the rent. But what we've tried to do in this bill is be really narrowly tailored to prevent landlords from essentially using information that we think are not predictive. And we think the vast majority of landlords wouldn't even really be denying people for those reasons anyway. We think probably the only reason they are denying them in the very, very small number of cases they are is because they're using it as a proxy for source of income discrimination. So this bill really kind of is the unfinished business of the Home Act. And I just want to again reiterate that I really appreciate Mr. Greenfield, Mr. Cantu, and all the landlord advocates for kind of meeting us halfway here and coming up with a product that's workable for them, but I think also will make a difference in a lot of tenants' lives as well.
Thank you. Thank you to the bill sponsor for that, and thank you for being an example of how we can work together to get some bills across the finish line. Delegate Weibel, I see your hand is up. Did you have a question?
Yeah, Ben, I thought I heard you say something about can't discriminate based on source of income. I thought that was a bill that passed the General Assembly a couple of years ago. Is that in this bill as well as amended?
Thank you for the question. Part of housing discrimination is based on source of income. That's an existing prohibition. However, I think what the bill is doing as it relates to that provision is saying that a violation of this section, the bill as amended, is also a discriminatory housing practice. So I think perhaps that's being done just for clarity and to avoid confusion.
So what we're left with, I heard the bill sponsor say you can't use old information prior to holding a voucher to verify income. Is that the only thing the bill's doing right now, and as well as establishing these discriminatory housing practices subject to the Commission on Civil Rights?
Yes, the main thrust of the bill is this part about how a landlord may not refuse to rent based on to a tenant based on their income, prospective tenant's credit score or a lack of credit score, and then any adverse credit history during the period when the tenant did not have the subsidy. So I think that's the main central part of the bill. And then there's those qualifying provisions below it about, things that the landlord can do related to that.
I think the bill sponsor wanted to add some more color to that.
Yeah, thank you, Mr. Chair. I'm happy to lay it out for you, Delegate Weibel, super simply. So basically, a few years ago, as you recall, The Home Act bans source of income discrimination, but there are still a couple ways that we think that landlords are trying to basically, like a very, very small minority of landlords are trying to get around this. So the first one is they're doing income testing on the entirety of the rent instead of the small portion that they owe that's not covered by the voucher. Now, everyone has been in agreement during this entire process, including, to their credit, the landlords, that that process is probably already illegal, but it certainly should be spelled out as illegal. The only contentious part of this was the bill also says you can't use credit scores and you can't use bad credit history from before the tenant got the voucher. Those were the things that were a little contentious. The credit score thing is still in there. The reason that we put the credit score in there is it's not predictive if a tenant is not going to pay. So really the tricky thing here became the adverse credit history before the voucher. The reason that was tricky was because the landlords made a really good point. They said, Vaughn and they said ECM, we don't know sometimes when the tenant got the voucher. So how can we possibly ignore adverse credit history from prior to them getting the voucher if we have no idea when the hell they got this voucher? So with the amendments that we worked out with them, it essentially says that if they don't know when they got it, it's not in the documents, no one's told them, then they can just ignore that. It's just status quo. It's only when they know when the tenant got the voucher that they need to ignore the pre-voucher history. The reason we want them to do that is because if someone's got a voucher and since then they paid their bills on time and they only had problems paying their bills from before they got the voucher, then we think that's a pretty good tenant, because you got 80 or 90% or sometimes 100% of their rent being paid for by the federal government, and they haven't had any problems with bills since they got the voucher. Then if they're getting denied from old stuff, we think that's probably not legitimate. That's probably a proxy for source of income discrimination. But we had to work out those details with the landlords for these scenarios where no one knew when the voucher actually came through. And so that's the reprint ahead of you. And then also, if you look in the reprint, you'll see that we put some safeguards in there, additional safeguards into landlords to make it crystal clear they can still income test the portion that the tenant has to pay. So the tenant still owes, let's say, $500. The landlord can still do some kind of income multiplier or verification of the income that the tenant actually has to pay. And then we also even put in there spelling out super clear all the different other tools the landlords have to test these tenants to make sure they're not going to screw up the property or they're not going to, do, shady stuff. So they can still look at references. They can still look at eviction data. They can still look at tenant screening reports. And we spelled that all out super clear in the bill. And so that's the bill essentially now says landlords should not consider old, faulty, non-predictive information. And if they are, they're probably just trying to discriminate. But they can consider stuff that is predictive and is legit. And so, again, we worked this out. It took a long time. That's why part of the reason that we didn't really even have the amendments and all this ready to go for y'all until fully this afternoon, I appreciate y'all's patience, is because it took a while to work out all these mechanics with the landlords, but I think we finally got it done.
All right. And Ben, what are the penalties for a violation of the civil rights?
One moment. Let me see if I can.
I think the civil penalties that normally are the case.
Yes, it's a civil action in circuit court. And if the administrative law judge finds that the respondent has engaged in a discriminatory housing practice, the judge can assess appropriate relief, including damages, injunctive, or other relief, and may assess a civil penalty against the respondent. And they can also award actual or punitive damages and attorney's fees.
All right. Thanks.
All right. Is there a motion to move the amendments?
Move the amendments.
Is there a second?
Second.
All right. All in favor of the amendment, say aye.
Aye.
All those opposed? The ayes have it.
Move the bill as amended.
Is there a second?
Second.
All right. The bill has been properly moved and seconded. Is there any discussion? If you're talking, I can't hear you. And if your hand is up, I can't see you. All right. All right. All those in favor of the bill, say aye. Make sure your hand is up so my team can see and read.
Aye.
See and read. All right. All those opposed?
No.
All right. We got another party line split here. All right. Thank you. All right. Next bill. What's the next bill we have here? 810. This is the State Department of Assessments and Taxation blockchain-based real property title pilot program. Emphasis on the word pilot here, folks. Program from Delegate Taylor, HB 810. Ben, can you briefly give us a quick summary of the bill?
Okay, thank you, Mr. Chair. The amendments we have that have been sent out convert the bill into a study to address the fiscal impact. And they also are conforming the bill with the Senate cross file, which was also voted out. The fiscal impact is introduced for the bill, notes that the general fund expenditures would increase by an estimated 3.4 million for contractual staff and one-time programming costs. However, most of the fiscal impact in the fiscal note appears to be tied to the requirement that SSTAT with the judiciary and a couple of other entities create a blockchain registry to record and verify digital titles, and then a requirement that a secure application programming interface be created for law enforcement and courts to validate titles in real time. But as amended, the bill is requiring SSTAT to conduct a study to evaluate the use of blockchain, real property, lease and title recordation and verification. The study is going to evaluate blockchain for verifying property ownership and leases, and then assess the potential for the use of blockchain to assist law enforcement and courts with resolving squatting disputes. There's no registry being created or the requirement to create an application. And then the amendment adds a couple of entities to be conducting the study, which are Maryland Legal Aid, Public Justice Center, and then third-party technology vendors, which I think is based on, potentially those vendors providing some sort of product in the future, potentially.
So Ben, if you can run that back, I'm trying to make sure I understand. So the amendments significantly changed the fiscal note, I assume?
That's my understanding as well, and that's based on looking at the fiscal notes, it seemed like the main driver for that was the blockchain registry, which was going to have that intensive staff requirement for building that out. And then also the cost associated with this application, both of which have been struck from the amended version.
Okay. Is there someone from Delegate Taylor's office here? I don't see anybody.
I did, and then Mr. Chair, if I may.
Go ahead.
Thank you. I did also submit the amendment version to appropriations, and just for what it's worth, regarding the potential fiscal issue, was just noting that it did pass the Senate. So I assume they also have some procedures there too.
Okay, so it sounds like we're in a good spot fiscally. I just want, is there a explicit cost that it now has? I just want to make sure we have that number. We don't have that number. Okay, Madam Vice Chair.
We can move it now and then check on the cost, just so if there is a number that sort of sends it back or requires that we not move it forward, but we can move it out of committee today and double check on that later.
Yeah, I just want to make sure we have a number before we, I like having that number. I know Y will appreciate that too. All right, is there a motion to move the amendments?
I'd appreciate it more if we knew the number ahead of time.
No, I hear you. I don't want if the number's good, I don't want the reason that we didn't move this bill. We can wait until we have a number before we move it out of a full committee. You got my word on that, okay?
Yeah.
All right.
Now, Mr. Chair,
Yes, sir.
can you hear me?
Yeah.
Okay.
Is there a motion to move the amendment? Did I hear a motion to move the amendments?
Move the amendments.
All right, is there a second?
Second.
All right. All those in favor of the amendment say aye.
Aye.
Opposed, no. The ayes have it. Is there a motion to move the bill as amended?
Move the bill as
Move
amended.
the bill. Second.
Second. All right. All right. The bill has been properly moved and seconded. Is there any discussion? Seeing none, all those in favor of the bill say aye. Please raise your hand. Again, you have my word. We will not move the bill out of main committee until we get the numbers right. There we go, Wobble. All right. All right. All those opposed?
Oh, sorry, I was.
Okay. I see. Is that Steve? Is it Steve? Is that you too, Chris? I'm sorry. Let me just probably.
I'm down.
I'm down.
Okay. All right. So Aaronson Adams are a no-go. All right.
And I guess I'm trusting on this one.
Look, I'll get you the number. I promise. I will. All right, I'm a man of my word. I will get you that because I'm a man that believes in numbers as well. Some of my friends call me cheap, but I call it being frugal.
Yeah, it's frugal. Yeah.
Frugal, that's right. All right, House Bill 920. I'm actually we are gonna hold this bill. I've had some discussions with council, and my concern here on this bill is that we got to figure out some language, and I think the vice chairs also have some conversations with the bill sponsor. The issue we're having here on this bill, and I'll let the Madam Vice Chair, did you want to comment on this bill?
I did once you were done.
Okay, yeah. So with this bill, the intent of the bill is great. What the bill's trying to do, I think, is a good thing. I think mechanically it's going to be difficult because of the limited amount of service providers that actually can do what the bill's asking to be done. So we're trying to figure out some language to make sure that it's a fair bill in the regards of who will be taking on the responsibility on the service side. But Madam Vice Chair, you want to chime in?
Sure. I think I would just say this is the bill, if folks remember, that requires the filing with the sale of certain properties. And the concern was that the system through which they would file is a proprietary, it's one particular business that we would be naming in statute that the filing has to happen with. I did speak to the sponsor, who I don't think is here. She can wave her hand. And she said she had been trying to find another pathway, and that for a variety of reasons, she didn't believe that SDAT would work. I spoke with counsel, who had some other suggestions, and I just thought, Mr. Chair, we could take maybe 2 or 3 minutes if people have other ideas to share. We don't have amendments right now, but if people have other ideas of another path that would allow for the transparency. I mean, the bill's trying to create transparency that would allow for that transparency, but do it in a way that doesn't direct people to one particular company.
Yeah. Is there anybody on the call that is from, I'll say, that community, that if you want to raise your hand, if you have any ideas or thoughts on how to do this? And again, we can also take this conversation offline. I know it's late in the evening. And we'll have more time to work some bills next week. I think we'll have no bill hearings next week, is my understanding. So we'll have time to really, we'll be doing a lot of subcommittee meetings next week, folks. All right, seeing no one raise their hand, we're gonna move on. I want to, the hour is late. I'm tired and hungry. So all right, House Bill 956, condominiums, buildings more than 40 years ago old. Keyword here is study, folks. It's a study. Council, if you want to go ahead and give us a brief description of the bill and what the amendments are doing to the bill.
Okay, thank you, Mr. Chair. So the fiscal impact in fiscal year 2027, the general fund expenditures increased by $75,000 for DHCD. There's no local fiscal impact. There are amendments. The bill requires DHCD to study buildings in the state that are more than 40 years old and contain a condominium. DHCD must submit its findings to the General Assembly by December 1st, 2026. The bill is introduced, required that the study determine the age, among other things, required that the study determine the age and income of each unit owner. The amendments change this to averages to address some of the testimony that was submitted on the bill.
So, and with the amendment, there's no change to the fiscal note on the amendment? It's
okay. If I may, Mr. Chair, I'd be speculating a little bit, but it's possible that perhaps maybe the fiscal note would go down a little bit just because it's dealing in averages as opposed to exact numbers, but yeah.
All right, so it's a one-time, it'd be a one-time 75,000. This isn't going to be just a study, so it's one-time 75,000. Yeah, okay, all right. Go back so I can see. I'm trying to double. Delegate Weibel.
So is the intent of this bill to eliminate the required reserve studies and funding?
Madam Vice Chair.
Yeah, my understanding is that there's this recognition that there are many condos where there is a difficulty meeting the reserve. And I think the concern is that in communities where there is particular vulnerability, so people on limited income or seniors, unlimited income in buildings that are particularly old, so they have higher potential reserve study costs, that there may be a need for the state to think about some sort of policy change or intervention or support or something. And I think, as I understood the bill's sponsor testimony and the testimony of others who supported this, that the idea, oh, he's here, I didn't realize he was here. Well, let me finish my sentence and then he can speak to it, was that if we gathered this information, then it would be possible to know really the size of the challenge, and if there's a need for an intervention. But since he's here, I'll let the chair follow him.
With a good delegate from the 41st district, please chime in here.
My pleasure. I can't say it better than the good vice chairwoman just said. This is a study. The intent is not to get rid of the obligation, but to see if there is a need for the state to assist people in meeting the obligation, because it has become a burden for many people.
Got it. Delegate Wobbles, do you have any other questions?
No, so we've created the issue and now we're going to come up with a program to fund it.
Well, I would say, if I may, Mr. Chairman.
Go ahead.
We brought the issue to the attention of the department and the committee. And if there's a need for a solution, then the case would have to be made that there should be state funding to assist these condominium owners of limited income.
Okay, thanks.
Okay. All right. Thank you, Delegate Rosenberg, for you joined like right on time. It was like I don't know how you did that.
Oh, I was here, but
okay.
I was undercover.
Okay. All right. Okay. All right. All right. You know, it's tricks of the
I'm
trade.
not that good.
When you've been here, what, 40 years, you know all the tricks of the trade, even in the virtual setting. My you know,
I didn't know virtual setting 40 years ago, my friend, as you know.
Right.
The amendments.
All right. Amendments have been is there a second?
Second.
All right. All those in favor say aye. Raise your hand, say aye. Aye. All right. All those opposed? All right. All right. The ayes have it.
Move the bill as amended.
Is there a second? Is there a second?
Second.
All right. Thank you, Delegate Chi. All right. Any discussion? I feel like we've had a good discussion on this one. All right. All those in favor of the bill say aye. Raise your hand.
Aye.
All right. All right. All right. All right. All those opposed?
No.
All right. I think it's another party line vote here. All right. Thank you all. All right. Next bill, I think we're just moving to the discussion portion. And my understanding is,
Mr. Chair, I think we have amendments on 502.
Oh, we do have amendments on 502. Okay.
Did those go out to people?
Did they get out to folks, Ben? If not, I'd rather hold it if we didn't get it out to folks in time.
I think we're still going through those, Mr. Chair.
Okay. All right. So we'll tackle 502. Again, just as a heads up, we're gonna have a lot of meetings next week, so be prepared. So we'll move to just discussing House Bill 774. I know we're still waiting for amendments on the other condominium bill from Delegate Tarassa, but we'll hold off on that for next week. I want to reserve. It's already almost 8 o'clock. I'm gonna give it 10 minutes, folks. Just a quick conversation, and we'll do a deeper dive next week on good cause eviction. I know that this bill was a long hearing, so I was going to, re-wet our palates on what the bill does. There's no amendments currently. I know that on the Senate side, they are exploring various amendments on this bill. So I want to open it to discussion. And again, if folks want to, if folks from various organizations want to have the opportunity to speak, I would ask that my colleagues would point their question either to that individual person or their organization or that area, so we can pinpoint how to get some more information and back and forth here. We want to be respectful in the conversation, but we want to be just a reminder that we will do a deeper dive next week when it's not 8 o'clock at night. All right. So opening it up for discussion, but we'll start with council. If you can please briefly describe, as brief as possible, what this bill does. I think we're very familiar with what it does, but just a quick refresher.
Okay, thank you, Mr. Chair. There's no state or local fiscal impact. What the bill does is authorize a county to enact a local law that prohibits a landlord from failing to renew a lease during the lease period or seeking to eliminate a holdover tenancy without good cause. Good cause is enumerated in the bill. Things like a tenant engaging in illegal activity on the premises, or the landlord wanting to recover the premises for their own use. And the local good cause ordinances adopted by a county apply only to a landlord with 6 or more residential rental units.
All right, thank you. And I know the bill sponsor is Madam Chair. I know she's busy tonight. I think she's hosting she's with her members at an event this evening. But want to open up to conversation. I know the Senate has been working on amendments. I guess I'll open it up first. If someone from AOBA, is anybody from AOBA or the realtors, if you all can describe just like what is there any? Oh, real quick, Madam Vice Chair.
Sorry, I wonder if we want to hear. I mean, I can speak to the genesis of the bill.
Yeah.
Or maybe we can hear about the sort of thoughts behind the bill before we hear.
Yeah, no, that's fine.
Concerns about it.
No, no, I agree. That's a good call. I just wanted to. That's a good call, Madam Vice Chair. You go ahead and start there, and then I want to make sure we understand what amendments are floating in the air across the hall, just so we can know what's all there. That's all. But go ahead.
Okay, I think I'll just say, having worked with a sponsor on issues of, within our community that we share, Chair Wilkins' bill. And so there's a number of issues that this bill is trying to address. The first issue that it's trying to address is community stability. And so in the same way as if you have a community where there's a lot of turnover and where people are living, it has a lot of implications for families. It has a lot of implications for children. We hear from teachers who talk about children having to move schools on a regular basis, the impact on that. The impact on families of moving a lot, the difficulty of stable employment, and questions about transportation, especially when people are trying to stay on public transportation. And then just the impact of, there's a lot of research that talks about stability of communities in terms of relationship building and how relationships help with physical and mental health of the people in those communities. So the more you can have stable communities, the better it is for local economies, the better it is for school systems, the better it is for the people in those communities. And so once you sort of establish that, then the question is, well, what are the tools that we have to create stable communities? And one of them is you want renters who have a home to not have to move homes on a regular basis, 1 year, 2 year, 3 years, without a reason that they have to be forced out of their home. And so that's really what this bill gets at. I would just I would just want to reiterate that it is enabling. So we could pass this bill and there could be no change anywhere in the state, or we could pass the bill and a local jurisdiction could say, yes, we'd like to implement that. And then a local jurisdiction could figure out how exactly they want to implement it within the framework of the bill. I'll say just two other things, one of which is that, so what the bill does is it says you can't ask a tenant to leave unless one of these good causes is in place, or you as a landlord are trying to move into that unit, or any number of things. I won't go through the causes themselves, but they get at a lot of the concerns that people have. So that's one piece of it. And I think that the last piece, I mean, the primary issue is the stability of communities and people being able to stay in their homes long-term. But the second issue that is really significant for a lot of the people I represent, Delegate Wilkin represents, is retaliation. And right now it's very difficult to prove that a tenant has been evicted at the end of their lease for retaliatory purposes. So even though we have protections against that, that's a very hard thing to prove. But what we see a lot in our communities is that we have tenants who will say, well, yes, I have rats, yes, I have mold, but I'm afraid to speak up about it because if I really advocate for this mold to be addressed, or the rats or the whatever it might be, then I could, when my lease is over, they won't renew my lease. And so that's the second thing. So it's the stability of communities, and then really making sure that tenants can speak up, that there's not a fear of retaliation at the end of their lease. Because right now a landlord can let them get to the end of their lease and terminate it and not have to give any cause. And so there's really no way to protect against the retaliation.
All right, thank you, Madam Vice Chair. I know, Ben, can you refresh what's the under current law, just so we understand the context of the situation when someone's getting evicted or not evicted, when someone's lease is not renewed. Remind us, what's the current law on notice on that? Is it 60 days, 90 days? I always get confused. And maybe locals, I think some jurisdictions do it further out. I think it's 60 or 90.
Thank you, thank you, Mr. Chair. Yeah, the notice, it does depend in part on the duration of the tenancy. But if the term is for, if the parties have a written lease for a term in the excess of 1 week or a tenancy from month to month, notice is generally 60 days before the expiration of the tenancy. For those year-to-year leases that are a little more common, written notice is 90 days before the expiration of the current year of the tenancy.
Got it. All right, so I want to be a good steward of folks' time. I want to open up the floor to members of the subcommittee. Are there any questions you all have? And again, we'll do another conversation next week before we consider moving the bill. But is there any questions you all have for members on the call or questions you have for council to put it on the record here in the subcommittee? Not all at once, folks, not all at once. It sounds like folks are ready to do a deeper dive next week, which is understood because it is 8:02 p.m. All right, with that said, I appreciate y'all for joining us this evening. It looks like we are not gonna do any further discussion here. Some people are pretty much satisfied. Is there a motion to adjourn?
Motion to adjourn.
Second.
All right. We are adjourned. I will see you all on the floor in the morning. Have a wonderful evening.